All right, in order to be a good financial advisor, you need to understand the last will and testament. And so what we're going to do today is I want to go through a will with you so you will be able to read it. Now, this is a basic will that you will see. There are different types of will. For example, you're going to have this basic will or a pour-over will. A pour-over will means that the estate is going to pour over into a living trust. All other wills are basically designed in this way that you're going to go through with me, and you'll be able to see that it's pretty straightforward. Wills are not that complicated, but I want you to understand the terminology in it. First off, you should see some kind of statement, basically where someone lives, and that they're revoking all other codicils and wills that they've ever created. Now, something that you will want to make sure, some form wills that are out there will have people's social security numbers on it. Ask that those be removed if an attorney is doing that, because this becomes a public document and people will be able to see people's social security numbers. Now, if they put their name and then just like like the last four digits, maybe that's okay. But we stopped putting social security numbers on wills a long time ago. The second thing is identification. So they're going to identify me through my family. So this is how we're going to come to know who we're talking about. My wife is Julie, and I have more than one kid. I have 5 kids, but I only have one kid on here, and I have my oldest son on here. Now, the next paragraph is an important paragraph because you want to see if your client has more children. Are they automatically going to be added, or are they going to be added over slow, or do they have to go back to the attorney? Now, every competent attorney that does estate planning is going to add a provision saying any additional children are automatically added and included. We have some more things in here, some language in here about using genetic material to create a child after someone's passed away. So basically what that is talking about is, hey, if I die and you take my genetic material and create a child, I don't want that child to be considered a descendant, even though under the law they would be. And with technology coming about, you need to be kind of aware of that as a financial advisor. It's not that big of an issue because maybe some people do want it, and so it's not in the will. But if you see some kind of language like talking about genetic material, then you know that it's referring to that situation. And then the next part is going to define what my descendants mean. I use the word descendant. Some people will use the word beneficiary. The terminology may change with the attorney, but I'm going to use my descendants, and my descendants are going to refer to my children and any of their blood children. And I'll get down where I define this term later on in here. A memorandum. So you might see in a will where an attorney is allowing someone to write a document and leave it with the will to leave their household and personal effects to whoever they may decide. So think of it like this. Someone comes in and they want to leave their guns. They want to leave their guns to their son. And over time, the son shows he's not responsible. So now they have to go back to the attorney and change that specific bequest they made in their will. Well, instead of having to make a change every single time there's a little thing that changes in a family, some states allow you to do a memorandum. Now, in Texas, a memorandum is not where I practice. A memorandum is not legally enforceable. However, I've never had a case where someone argued about the memorandum. Now, it's key to understand, and always make sure if you're ever reviewing your client's will, if they allow you to do this, that they have not written on the will. I have to make very clear to my clients that your memorandum isn't you writing on the will. It's on a separate piece of paper, and you leave it with the will. A burial request, this can be quite long. I had a story with a lady that came in and she had 5 pages worth of burial requests, and it was a nightmare typing it in. But usually it's a 1-sentence, hey, just let my executor decide. This right here is a specific bequest. Now, as a financial advisor, it's important to understand how property is distributed in a will. So specific bequests come first before what we call the residue, the remaining property that's left over. Now, why is that? Well, it's logically that's the way it would work. First, you would distribute specific items that have been listed out, and then the remaining property is distributed. Now, get back and kind of think through this, and so you understand. So, if someone leaves a specific bequest of a house in a will, that means that if a person dies with only a home, which happens all the time, then the person who gets the house gets everything. And it's very important that you understand that as a financial advisor, because one of the biggest concerns is that everybody gets along after someone passes away. Now, here's another problem with specific bequests. Let's say dad decides, I'm going to leave the vacation house to my daughter, and I'm going to leave our primary residence to my son. And right before he passes away, they sell the primary residence. Well, the vacation house still goes to the daughter, and the son now gets nothing. And so this is the problem with specific bequests, is the client has to be on top of it. They have to constantly be watching, okay, what did I give to people and how did I give it? And so I don't like putting specific bequests in there unless it's absolutely a necessity. But, some people want to get down into the details, and every little item they want to go through and distribute it. Where I try to explain to people, you can do it that way, but you need to be on top of this. And the odds are, before you pass away, you're not going to be on top of this. You're not going to be thinking about how your property is going to be left in your will. Now, I put a specific bequest in here. And when I drafted this, I'm doing this as an example. I'm doing what is called a life estate to my wife. Okay, so here becomes a common situation, or actually, I had a case just like this where mom dies, leaves home to son because she's worried son won't have some place to live, and really what she wanted to do was leave what's called a life estate. What a life estate is as long as my son is alive or living in this house, he can live there and you can't sell it from him. But once he dies, then it's distributed equally. So when your client comes in, now you're not supposed to be telling them how to draft everything, but you need to understand these concepts so you can communicate to them as going, it sounds like what you really want to do for your son, because it's usually the son, because mom will have a relationship with son, and son is kind of, he can't get out of the house. He has a leaving the home problem. He's just staying at the house, and he's lived there, and he's in his 40s and 50s now. And so mom feels this obligation to take care of him. Why do I say mom? Because usually dad kicks him out of the house, where mom will continue to keep them in the home because that's where she gets her love and affection from, is her son. And so she keeps him in the home. And this is so common, happens all the time. And she loves this son so much, but he's totally inept. And the other siblings totally despise him because he just mooched off mom his whole life. And now he's getting the whole house. And of course, usually he'll have a drug problem. He'll have some kind of issue that will result in his inability to actually keep the property. So I would explain to your client at that point, what you really want to do is leave a life estate. Now you will get, usually in a will, now mine are pretty straightforward. I put all of the important stuff up front. Sometimes wills, you have to dig through them to find something, but you want to find what is called the residue clause, or what will be termed as the outright distribution of the remaining property. And it will be its own clause, and you just got to look through, because this is what you want to check to make sure that it's right. This is the most important part. This is the key. Make sure that, I would read it through with as a financial advisor, going, well, let's just read it and make sure it's exactly what you want. And I actually read it through with my clients. I say, in this case, if my wife survives me, I give her all the residue of my estate. Of course, that's what I want. And if I die, my wife's alive, I want her to get everything. If my wife fails to survive me, I give the residue of my estate to my descendants who survive me per capita each generation. Now gets to terminology that's important to understand. It'll make you look really smart and competent. Per capita each generation and per stirpes are two different distribution schemes that have been created over a long period of time. A per stirpes or rights of representation kind of a distribution. What that's saying is, if I die and my wife's gone and I have 3 children, I want my property divided equally among those 3 children. And per capita and per stirpes are the same in that situation. But where per capita and per stirpes differ is if there's a situation where where all the children have passed away and all we have are grandchildren. And I'm going to use this example because this is actually a client I had. He had 2 kids. Well, one kid had 8 kids, and the other kid had 1 kid. Well, in a per stirpes distribution, we don't care how many grandchildren there are. 50% went to the 1 kid, and 50% was divided 8 ways among the other grandchildren. So think of that. There's 2 children, 50-50, and even though both of them had passed away, the child with 8 kids had to distribute 50%, and the child with 1 kid had to divide 50%. Well, of course, when this happened, and I was distributing the property, and I saw 1 grandchild was getting half of the property, while 8 grandchildren were dividing 50% of the property. And the 8 grandchildren were a lot harder up because the 1 grandchild already received a large inheritance from his parents. I saw the unfairness of a per stirpes distribution. So I just went to a per capita each generation. What per capita means is if all my children have passed away, so in this case, if those 2 children had passed away, the grandchildren move up and they become as if they were children, as if they were the children. And so everything would have been divided equally among the 9 of them. And I like that distribution more. I sometimes talk to my clients, but it's important to understand that terminology. When you get to it in the will, it will make you, it's always going to be in every will. So you just need to memorize it and learn it and understand it, because once you understand it, then you'll be able to really be able to advise your client and look like you know what you're talking about. Next is if my wife or my descendants don't survive me, okay, so no one's there. I put 1/2 to my heirs and 1/2 to my wife's heirs. That's how we would distribute our property. Half would go to my family, half would go to hers. Now, you need to understand what that means when it goes to heirs. In the state of Texas, what that means is first to parents, then to siblings. So understand it. Now, I put a testamentary trust in my will, a supplemental testamentary trust. And what this is saying is, I'm assuming, let's say Dallin, my son, was he's never going to be able to work. He's going to need government benefits. Well, I don't want the government to get my property. I want it to go into a supplemental needs trust. Now, there's a difference between a supplemental needs trust and a special needs trust. A supplemental needs trust is a third-party special needs trust, and what that means is that I'm creating it for my son. It's third party. Me, it's my money. It's going to my son, but because I'm not giving it to my son, the government doesn't get it at the end after he passes away. Well, first party special needs trust, the government is the beneficiary after the person passes away. So if Dallin himself went and created a special needs trust, he went out and created it himself and put his money in there so he qualified for Medicaid. Well, then his money after he passed away, if any's left over, would go to the government. You don't need to understand that until long-term care planning, and I'll go over that with you. But I want to give you a basic understanding of why it says supplemental, not special needs. And basically, it's a simple, straightforward trust in here, and it's explaining everything. Now, I just wanted you to see what you'll commonly see in wills is a testamentary trust. That's a will that's inside of a trust that upon their passing will be created. So we don't want to create it now. It's not a living trust. It's a testamentary trust. It happens after someone passes away. Executor and trustee. Now, I usually will have 3 generations in here. I like to think if someone's in their 30, a generation older, my generation, and generation younger. Of course, my wife's going to be my executor. I usually have 3 in here, but I was quickly drafting this. Vacancy. So Dallin, if his trust becomes vacant, I put that someone else can be appointed. No bond to be executor. So if you see something about bond, that's just basically saying most states require a bond to be issued by an executor when the property is going through probate. I don't want that to happen. An independent administration. In the state of Texas, you're not going to see this language in every state. But what that's basically saying is any kind of administration after someone passed away. Administration is referring to the probate of an estate. When it's being administered, in Texas, we allow it to be independent of the court. So the court just approves it, and then the executor could do everything. Other states say, nope, a judge has to be involved in every step of the process. If that's the case, you want to avoid probate and make sure that they have a living trust. And you just got to find out from your state what that means. And I'm going to go through all these concepts with you over and over again so you get them. But right now, I'm trying to give you a basic understanding of each paragraph. Expenses and compensation. Basically, what expenses and compensation is, someone going to get paid to be the executor? And usually, of course, no, they don't. It's miserable. It's like my professor used to say, being executor is like doing drugs. Just say no. All right, we have some other provisions in here. These 3 provisions are just referring to an administration of the estate and how co-executors would work. What if someone dies in another state than Texas? Well, I want the Texas state law to be used. You will see a guardianship provision for minor children in a will, usually. There could be an attached document, but we're going to put this in here to set up a guardianship because I have little children. You're going to want to make sure if people have little children that guardianship provisions are set up. This is more important than anything else. Make sure your client has that. You have a young couple comes in, they're 38, and they have a little child, and they're like, oh yeah, we don't have our will or anything. Well, at least get your guardianship provision set up, and that can be a separate document than the will if they just don't want to do a will at that time. But you send them to an attorney. Do not draft these documents yourself. Just have a relationship with an attorney. And hopefully that relationship's strong enough that you're going to get referrals from him. Executor and trustee powers. I've listed off all the powers to be your executor. Basically, what this is saying is, in Texas, since we have an independent administration, I have to give the power to the executor to do things like sell the property. And so the will has to have this language. This is the problem when people write their own wills. They think all that's important is, I'm going to handwrite a will and it'll be good. Well, they don't understand things like this. Like, hey, you have to give powers to your executor to do things, or the judge does everything. And now you've taken a probate that should be simple and made it really complicated. So I've listed off all the powers in the state of Texas. A spendthrift provision. This is kind of an interesting provision because I had this financial advisor come speak to a group, and he was an interesting guy because I don't think he realized that as an estate planning attorney, I've done 5,000 estate plans, and he kind of sells himself as an estate planning financial advisor. And now, of course, he doesn't draft any of the documents. He sends it to an attorney. But as he was speaking, he goes, I have my certification. I know all about this process. I know all about wills. He started to say things that were just not true at all. And he was referencing a spendthrift provision. But he says, there's a provision you can put in your will that would make sure your creditors can't get your property. It's like, well, no, that's not what a spendthrift provision does. A spendthrift provision prevents my beneficiaries' creditors from coming in and taking part of the estate. not my creditors. And it was just a misunderstanding that he had. But I'm like, well, you just advised everybody in a room, and little did you know that there was I consider myself an expert on this, sitting in the room listening to you and realizing, hey, you work in my community. If I ever get a probate where it's this guy's will, well, I know what he goes and says to people. So it's very important that you learn these terms and really understand what they mean. A splinter provision does not protect the actual person when they pass away from their creditors. Their creditors have to be paid. There's no getting around that. We don't have magical things to not pay creditors when people owe money to people. All right, so the maximum duration of trust, this is what's referred to as the rule against perpetuities. Don't waste any time on worrying about that. That's the attorney's job to worry about. It's a complicated rule, and it's been around forever, and it's to prevent, in some states, they don't like dynasty trust or trust that lasts forever, and they want it to end at a certain time. And that's basically, if you go back in time, in America, we decided that we wanted to get rid of back in the day, we wanted to get rid of the aristocracy. Now we're trying to create it again, but we didn't want these trusts that controlled all this land for generations and generations, and that benefited one family. And so that's what the rule of perpetuities was created for, was to stop aristocracies from being formed through trusts. Now they're undoing all that in a lot of states. So you just need to be aware of it. Accounting, understand that it's very important that a will gives the right to the beneficiaries for an accounting, because the biggest amount of theft happens when someone passes away. And you're gonna find that out when you start doing this stuff and you have clients that start passing away, is kids are going to start stealing property and destroying the family, and it's nasty. Survivorship provision. So whenever you see a survivorship provision, what that's just saying is, hey, someone has to live a certain amount of days. In my case, I said 30, in order to inherit. Now, I'll give you a client that I had. They came in to do a probate. A house was left to son. Yeah, it was a mom that died. She left the house to son. See how common this happens? And she left it to son, and son died 31 days. And I ran to the will. I was looking through it, and the survivorship provision said 30 days. So the property passed to him because he outlived her by 31 days. And so that house ended up going to granddaughter. Well, granddaughter, it was never the intention of mom that granddaughter get the property, because now the other kids got nothing, and granddaughter, because the only thing that was left over was the house, and granddaughter got everything. And of course, she took it all and ran. Payment of debts. Well, sometimes you'll see an attorney, they want to explain how debts are to be paid, because in certain situations, the law says, for example, funeral costs are paid first, then legal fees, and then we have secured creditors, so like a mortgage is paid, and then the last is going to be unsecured creditors. Well, how do we prioritize unsecured creditors? Does your client want the mortgage of their house to be paid off upon their passing if they're leaving a specific gift? Those are certain considerations that are being made. Now, you might be getting a little overwhelmed at this point, and you should be, because this is overwhelming, and this takes years to learn all these things. The key is you don't need to know all these things. You just need to generally understand what these provisions are, and understand that you don't need to go read an attorney's payment of debt schedule. It's a waste of your time. What you should have really got out of this is the first couple pages are all that you're going to really read, because you just want to know, where is that property going, and did the attorney draft it right? My payment on debt schedule is going to be the same for almost every one of my clients. It might change once in a while, but you don't need to worry about this. Wills are not contractual. If you ever see a provision like that, it's basically, I'm saying husband and wife came in, they made no agreement that they were going to leave property a certain way after they passed away. There was no contractual agreement made. A descendant. Well, actually, here it is. I define what a descendant is. And generally, a descendant, if you really want to get into this and learn and make sure that the language is what your client wants, you can learn what you can go find out how the attorney defines a descendant. I define it as your bloodline, or any kid adopted under the age of 14. 18. I did 18 in this. So any kid adopted under the age of 18 is going to be considered a descendant. So who is not a descendant? Well, the spouses of my kids wouldn't be descendants of me. That's important to understand. And almost every will is written that way. They're never put as the spouse of kids. And the second thing that's going to be is step-grandchildren. Step-grandchildren are not included in this list. So my son gets married to someone that had a kid, and let's say he's my only kid, and she had a child before the marriage, and that's the only child, and I consider that kid my grandkid for all intents and purposes. For 40 years, I consider that kid my grandkid, and then I die and then learn that the descendant, that a stepchild was not included, step-grandchild, that's going to be a sad day. So it's certain things you need to understand. Look at the family. Usually people don't want to include their step-grandchildren, but there might be a reason why they do. And it's just something to be aware of. Genetic material, I'm just describing what that means. Incapacitated. If someone's deemed incapacitated, they cannot be an executor. That's what I'm saying there. And I'm defining how someone is determined incapacitated. The governing laws of the state of Texas. This you will not see in most wills outside of the state of Texas, but it's so someone can keep homestead exemption. Usually if you read a section and it looks really confusing, you don't understand what it's talking about, look for this. Like, what code section is it talking about? And that will tell you what it's talking about. Texas tax code. Oh, it's talking about taxes. Texas property code. Oh, it's probably talking about property taxes. Yeah. And so then you would be able to understand that's something I'm not going to concern myself with. That's the attorney's job. I describe what a per capita at each generation distribution is because in each state there are different names for things. There are hybrid per capita distributions. There's rights of representation language that is used. And so I want people in other states to know when I use per capita each generation, what am I talking about? And I told you what I was talking about earlier. And then last, what you want to make sure where you're going to earn your money to, there's a no contest clause. Now, why would an attorney not put a no contest clause in a will? Well, there might be a good reason that the client could have said, I don't want that. I've had that happen one time, I believe, in 5,000 estate plans. But there's a big financial incentive for an attorney not to put a no contest clause, because if there's a no contest clause, that's going to stop fighting after people pass away. And probate is where attorneys make money. So if kids want to fight, it's a great place where I can make some money. So I'm not going to put a no contest clause. So you're going to want to make sure that, one, in your state, they allow no contest clause, and they're actually worthwhile. But the attorney's putting that in because you want to make sure that the attorney's trying to protect the client and may not, there's no legal, ethical responsibility to put in a no contest clause. I just consider it good estate planning. All right, and then you'll have a signing page. Now, this is the last thing. So if I was going to give you 3 things to check in every will. Number 1, the distribution of the property. I want you to make sure that the distribution of the property is happening. Number 2, that the people understand the executors who they picked. And then 3rd, I'd look at the back. Was it signed and notarized and witnessed properly? Because, I could be an attorney. I'm doing it in my office. Everybody's signing. Sometimes we're signing, 30 documents. And it gets a little crazy. And one witness misses. And the will is not valid. So that should give you a basic understanding of a will. And hopefully as we went through this, you kind of feel like, okay, I understand how this works. and I got a basic understanding. And hopefully you got a feeling that there's a lot to learn. And we're going to go through it and we're going to learn it all.